Bismillahirrahmanirrahim. Honorable Chief Justice Pakistan, Mr. Justice Umar Tabandiyal, Justice Syed Mansoor Ali Shah, Judge Supreme Court, Pakistan, distinguished guests, ladies and gentlemen, Assalamu alaikum, good evening. It is a privilege to have been asked to talk to this august gathering of distinguished luminaries of legal as well as other associated fields. I want to express my gratitude to this forum for arranging a conference on judicial perspectives on domestic and international arbitration in Pakistan. Life presents every person with challenges. In our society, the law matters, and yet for many people, justice seems to be elusive. Access to justice is a necessary part of making the rule of law fair for everyone. At Lahore High Court, we believe access to justice means that when people encounter life challenges, they can understand their rights under the law, protect those rights, obtain a fair outcome, and know that the result will be enforced under the law. Access to justice is high stakes. It routinely determines whether basic human needs for food, clothing, and shelter will be met, and it can mean everything for a person in crisis. Ladies and gentlemen, the Constitution of Islamic Republic of Pakistan ensures inexpensive and expeditious justice under its Article 37, Clause D. Keeping in view the desire of constitutional provision, Pakistani courts are supporting the ADR system in both civil and criminal matters, including even non-compoundable offences. It is observed by the Honorable Supreme Court of Pakistan in 2013 SCMR page 1281, which is as under. The purpose behind it is to provide a respectable and fair mode based on principles of equality of all human beings to reach some settlement compromise in the large interest of the civil society, and to bury the hatchet of revenge once and for all, so as to save other generations from facing the consequences of enmity amongst different segments of society aimed for satisfaction of endless personal vendetta. Ladies and gentlemen, as far as legal backing of ADR in Pakistan is concerned, Arbitration Act 1940 is its glaring example. The Act provides for arbitration with or and without intervention of the court. If any of the parties comes to the court and the other party seeks arbitration under Section 34 of the Arbitration Act, the courts are obligated to refer the matter to arbitration. In addition to it, there are provisions of pre-trial and post-trial reconciliation in the Family Courts Act 1964. The Muslim Family Laws Ordinance 1961 also provides for arbitration counsel in exercise powers in matters of maintenance, compromise, before effectiveness of divorce, permission for second and another marriage. The Local Government Ordinance 2001 provides for Musaliyat Anjuman offices to achieve amicable settlement of disputes. Customs Act 1969 provides for alternate dispute resolution. The aggrieved party has a right to apply to committee for resolution of their dispute. Income tax ordinance also enunciates alternate dispute resolution. Federal Excise Act 2005 and Sales Tax Act 1990 have provisions relating to alternate dispute resolutions. Similar small claims and minor offences courts ordinance 2002 also provides for amicable settlement of dispute between the parties. Likewise, Lahore High Court introduced ADR as a mandatory exercise in civil suits by adding Order 9B by notifying it on 15th August 2018. Additionally, in various judgments, the Honorable Supreme Court, while emphasizing the importance of ADR, has settled several principles in 2018 SCMR 662. The Honorable Supreme Court has discussed the grounds for setting aside arbitration award, which give guidelines for legal fraternity and businessmen. In another case, PLD 2017, Supreme Court 53, the Honorable Supreme Court of Pakistan settled the jurisdiction of courts that both courts wherein dispute arose and wherein arbitration proceedings conducted has jurisdiction. The Lahore High Court is also cognizant of the foreign arbitration awards, which are absolutely implemented in letter and spirit. To this end, then the Honorable Chief Justice of the Lahore High Court, Honorable Mr. Justice Sayyid Mansoor Ali Shah, now the Judge of the Honorable Supreme Court, came up with a revolutionary approach to tackle the menace of slow relief to the serving litigants by establishing alternative dispute resolution ADR centers in all 36 districts of Punjab, with 72 dedicated judges to help parties achieve an amicable solution to their disputes. To refer a matter to ADR center, the parties just have to give an application to the court hearing their case and have to consent to settle the matter through an ADR center. The judges in these centers are already trained by the Punjab Judicial Academy to help parties reach a settlement through mediation. Since then, 2022, 21,131 matters have been received ADR centers of Punjab, out of which 70% have been successful. The complete data is available on website Lahore High Court Lahore. Another major milestone achieved in Punjab by the Lahore High Court was in April 2020, when a working group had been formed headed by two honorable judges of this court, Justice Mr. Justice Shahid Kareem and Mr. Justice Jawad Hassan, comprising members of legal community, the Punjab government and the World Bank. The result was the Punjab Commercial Courts Ordinance 2021. The ordinance provides for the whole of the province Punjab a legal regime for early resolution of commercial disputes and expeditious disposal of commercial litigation of specified value. In this regard, there is a mandatory court-ordered alternative dispute resolution ADR under the provisions of Order 9B of the Code of Civil Procedure 1908. Statistics and data collected from these centers show encouraging results which indicate that ADR is increasingly popular in disputes between private individuals. These are all like the promotion of arbitration, measures that are effectively reducing reducing the burden on courts alone, and most importantly, improving access to justice and practicing and preserving the fundamental rights granted to the citizens of Pakistan under our Constitution 1973. In concluding about today's discussion, I am particularly pleased about 1. The references made about commercial courts and ADR working together to help with the reduction of court pendency issues in Pakistan. 2. The importance of standardized arbitration arbitration practices and procedure with the introduction of Chartered Institute of Arbitrators, Pakistan branch as the chartered body of ADR practitioners. 3. Importance of information exchange between dispute resolvers and the user's perspective in both energy and infrastructure related matters. The dispute causation report is timely reminder for us that avoidance is better than cure, and we need to act on recommendations to ensure disputes do not occur in the first place. Ladies and gentlemen, lastly, I would like to request that we work together on the following principles. A. Promoting accessibility, which is eliminating barriers that prevent people from understanding and exercising their rights. B. Ensuring fairness, that is delivering fair and just outcomes for all parties. C. Increasing efficiency by delivering fair and just outcomes effectively. To translate these principles into action, we need to pursue strategies to leverage and better adjudicate justice, resources and works to advanced training, practices and procedures to support the development and delivery of ADR practices and procedures at all levels. Promote less lawyer incentive and court incentive solutions to legal problems, and expand research on innovative strategies to close the pendency of cases in courts. Finally, what many people want most is swift and just resolution to their disputes and towards this end we must endure. One last thing, the Honorable High Court has arranged a visit to our Lahore High Court for our distinguished speakers, and I welcome you all to tea in the Lahore High Court Committee room. Thank you all.